Hello, good afternoon, everyone, and thank you for being with us. So we have organized this panel with the Digital Clearinghouse. So the Digital Clearinghouse is its aim is to facilitate the cooperation and the discussion between data protection authority, competition authority, and consumer protection authorities in Europe and beyond. This is an initiative which was launched already some years ago by the EDPS. And which is now organized by the universities of Tilburg, Namur, and the EPC, the think tank in Brussels, and it is funded by three foundations: the Open Society Foundation, Omidyar Foundation, and the King Baudouin Foundation, that I would like to thank here again. So we produce different background notes and organize some closed discussion and also open conference. You can find everything on the website, the digitalclearinghouse.org. So today we will discuss the issue of institutional design and enforcement. And as it is in the title, if we want to paraphrase Bill Clinton in the '92 US presidential election, it says it's the economy stupid. Maybe for Europe, we can say it's enforcement stupid. Because very often in Europe, we have very good rule, but sometimes the enforcement is weaker, and that's really where the problems lie. And there has been several panels on this issue in the conference, and we want to discuss that also here. We think the discussion is very timely, given the fact that the Commission has proposed last month two important proposals, which push for more centralization in the enforcement of those new rules, and in a way, I think make the European Commission a bit like the European equivalent as the US FTC, because the Commission could have antitrust power that it has already now, but also some new and concurrently regulatory power. And so we would like to discuss all of that, and we are very lucky to have an extremely good line of speakers, which are also very influential, and which have a very important role. So first we have Marie-Laure Denis. She's the chair of the Data Protection Authority in France, the CNIL, who has been extremely active, in particular against some big tech. We then have Andreas Mond, the chair of the German Competition Authority, which has also been extremely active against some big tech. No, you didn't target the same, so it's like a kind of market sharing maybe between both of you, I don't know. We will discuss. Then we have Bill Kovacic. Bill Kovacic is a professor of law at the Washington University and also at the King's College in London, but he's also a non-executive director at the UK Competition Authority and the former chair of the FTC. So a lot of experience for us. And then we have Inge Graaf, my partner in crime, if you could say, for the Digital Clearinghouse. She's associate professor at the University of Tilburg and a very influential writer on the regulation of the digital economy. So thank you, the four of you, to be with us and to share your experience and also your view on those new initiatives that are now being discussed by the European Parliament and by the Council of Ministers. So if I may, I would like first to give you your first reaction on what should be or what could be a good enforcement in the digital economy, being the data protection rule, being the antitrust rule, being the consumer protection rule, on the basis of your experience and on the basis of the proposal that the Commission has made, and as I said, clearly want to have a bit more centralization. So if you can first give us your first reaction in 5 minutes, and I suggest to start with you, Marie-Laure Denis. And again, thank you very much for being with us and for the time you give us.
Good afternoon, and to all, and many thanks to the organizers for having invited the CNIL to join this most topical discussion. As far as the CNIL is concerned, but it's the case for other European counterparts, 2020 has been a very important year in terms of enforcement. Over the last year, we have adopted a number of corrective measures with 49 orders, 14 sanctions for the CNIL for a total amount of fine of 140 million euros. the most emblematic ones being our December sanctions against Google entities for 100 million and Amazon for 35 million. Figures at EU level also demonstrate the same trend, with an increased number of cross-border cases initiated and of final decisions adopted in application of the one-stop shop mechanism, 89 in 2020. Several of our EU counterparts also adopted important decisions. Of course, administrative fines are not an end itself, but it's certainly a signal towards the main actors of our digital economy, and they contribute to our effort in ensuring compliance with EU data protection rules. Administrative fines are not the only means either. Our recent decisions towards Google and Amazon also include a compelling order to remedy the breaches identified within a given period, if not complied with, can expose the data controller to daily financial penalties. This is also a very useful tool to ensure compliance. Does it mean there is no challenges or changes ahead of us? Of course not. We need to coordinate and optimize our efforts for the enforcement and oversight of the digital economy. Today, the status of personal data has changed, whether for the users, companies, or in investors' minds. Legislators and regulators are here to accompany this change and set up an overall data governance framework that is fit for the digital economy. This is a key challenge, and this trend is actually a reality for us. And I can mention the CNIL regular exchanges with the French competition authority, the Autorité de la Concurrence, both informal and formal, on relevant cases. In this regard, we welcome the recent set of proposals for regulations from the European Commission, the Data Services Act, the Data Markets Act, and we should not forget as well the Data Governance Act. Once these new legislations are adopted, a key question will be about enforcement and which institutional setup is the most appropriate to ensure an efficient supervision and application of the law. We are all somewhat in a process of digesting the Commission's proposal, but when it comes to enforcement and oversight, I would say to launch the debate that we have to focus on three main elements: coherence, efficiency, and readability for consumers and companies. It is also essential to ensure that any new legislative proposal remains consistent with and does not undermine the level of maturity of the digital economy. There is probably no clear cut on how to regulate and who should be in charge. Regulatory fields are becoming more and more interlinked. Data protection considerations are now entering into the assessment of competition regulators. A similar logic is actually also undergoing in other direction, as data protection regulators can be faced with new cases as a result of market evolution and competition cases. So we need to have a debate on how to coordinate and optimize our efforts, and we need to be realistic but also optimistic about what can be achieved. That's what I hope for today's discussion.
Thank you very much. Now let's turn to Andreas Mund. This is also the enforcement issue. I mean, you have been very active in your country, and you have been, I think, you have thought a lot about also an optimal enforcement in Europe. So if you can share your thought with us, thank you very much also for being with us.
Yeah, many thanks, Alexander. Many thanks to the organizers for having me here today. It's a great pleasure. I mean, we look at all this from a purely economic point of view. We are a competition agency. It is our task to keep markets open. We have to keep markets contestable. We have to give a chance to competitors that are already in the market competing with the big companies. We have to take care of new entrants who want to come into the market. Just with the goal to protect innovation, to secure low prices, and to avert harm from the consumers. So this is a very economic point of view. And it is true that digitalization has brought a lot of benefit to people's life, and they should also be able to benefit from the competition in digital markets in order to take care for much innovation also in the future. So with this goal, we have done a lot of proceedings at the EU level, in Paris, in Bonn, in many other capitals around Europe. But when we talk about effectiveness of our interventions, we have to concede. I think many times as competition agencies with our proceedings, we could have had a greater impact on the markets worldwide, and that would have been desirable. So don't get me wrong in this respect. There have been very successful cases, but these cases have mainly been successful from my perspective when we have achieved an amicable settlement with the companies. For example, the Bundeskartellamt has achieved a settlement with Amazon back in 2019, when we reached, well, at least fairer terms and conditions of Amazon vis-a-vis the sellers that are active on the Amazon marketplace. We did in 8 months. Another proceeding that might be an example for the contrary is our, Light Tower proceeding against Facebook. We started that proceeding in 2016. We rendered our decision in 2019, relatively fast. But until today, we are engaged in court proceedings with Amazon. 2 times just in a preliminary proceeding that Facebook has set up at the higher regional court in Düsseldorf. So if you look at this, it is clear that we have to do something about the procedures on both ends here in the agency with regard to the administrative proceedings that we are pursuing. But you should also take a close look at the courts and proceedings there in order to come maybe to shortened proceedings here. We have lots of initiatives around Europe. There are a good many ideas how to improve the legal framework, how to speed up proceedings and make them more effective. There is, for instance, the CMA's suggestions in the UK on a digital markets unit implementing a firm-specific code of conduct. We are actually pioneering another approach over here in Germany with the just amended German Competition Act that has come into force just 10 days ago. It features a novel provision addressing undertakings with paramount significance for competition across markets. So we as a competition agency will be able to address these kind of ecosystems of digital conglomerates. And once we have a decision, and then once we have addressed a company to be of that paramount significance for competition, we can prohibit certain kinds of conduct to these kind of companies, like preferencing, like envelopment strategies on new market, or like hindering interoperability maybe by all the data that these companies possess. So this new provision combines in a way general principles. It is open to future strategies. Maybe that's a bit different from the DMA, but it comes along with concrete rules examples. So that will contribute to faster proceedings and earlier interventions, because we can also intervene on markets where these companies are not dominant yet. So that goes very clearly in the direction of the approach also of the DMA. It has a regulatory touch, but it is deeply rooted in competition law, because first of all, we have to find an addressee of our decisions, which makes it calculable for the companies who falls under the scope of this new provision 19A in our law. Maybe that is also a slight difference to the DMA from the European Commission. So I think these new instruments will make us faster, they will make us more effective, because here I fully agree. What we need is enforcement. We need to make a difference for the markets. Our decisions need to have an impact on the conduct of these companies in order to open markets up. We have learned some time, we have had successful proceedings, but I'm very confident our proceedings might even be more successful in the future with all these new tools that are at hand now. Thanks a lot.
Thank you very much, Andreas. We'll come back to you on the relationship between this new German law and what is proposed in the DMA. But let's go first to Bill. What is your view? You have an experience from the US. You know Europe very well. So do you see there is a problem of enforcement, and if there is, what kind of recommendation you could give to us on the basis of your experience?
Thank you, Alexandra, and very great thanks to Inga for the opportunity to be on the panel, and special thanks to Marie-Laure and to Andreas for framing the issue so well as a beginning. And I spent my time in the last 6 years on the board of the CMA, and I'm not speaking on their behalf, but I am drawing very heavily on developments, among which Andreas has already referred to. I see four big challenges that are not simply faced by the European Union and its member states, but are faced by authorities globally. The one is a knowledge problem. That is, these are extremely complicated and dynamic sectors, and a big challenge for the regulator is to know enough about what's going on to make good judgments. I've been struck at the CMA how a policy response in the last few years has been to create a special data team of technologists. And that group of technologists now has 40 individuals, and they're about to add more. And that was a conscious reaction to the realization that either you have to bring the expertise in-house or form relationships with other institutions, but that if you're not building and renewing your intellectual capital very quickly, you simply lose touch about what's going on in these sectors. The second factor, which Andreas mentioned, is speed. Can you intervene quickly enough to make a timely difference that makes a positive, has a positive impact? I just point to the 5 lawsuits now going on in the United States, 3 against Google at the national level and state level, 2 against Facebook. Very interesting, ambitious measures that seek restructuring of those companies, but the Department of Justice case against Google is not scheduled to begin its trial until September 2023. If it goes the full distance on appeals, there won't be a final resolution until the middle of 2026. That's 5 years from now. Now, a pending case does affect what companies do, but we can ask ourselves in this setting, is that fast enough? And the experiments that I think Andreas talked about to step up the pace of the resolution of matters becomes very important. Otherwise, you're chasing a Formula One racer riding a bicycle. Third challenge, policy integration. And Marie-Laure mentioned this already. The ideal solution, I think, in many instances, implicates at least the domains of competition, consumer protection, data protection. How do you integrate those disciplines? Do you do it by bringing relevant functions under the umbrella of a single institution, or do you do it by contract, by agreement that links distinct organizations but brings their expertise effectively to bear on specific problems? And there is the policy integration that involves, I think, a fourth and related point that Marie-Laure mentioned as well, and that's coherence, where you have so many actors at the national level, at the community level, and now internationally. How do you develop a set of principles that will provide effective protection, but at the same time, not send inconsistent and conflicting signals to firms that greatly diminishes their effectiveness. Because as we note, not only the striking developments in Europe, the question is Brussels basically going to be the international standard setting body here, or will we see divergent paths developing in the United Kingdom, ultimately in the United States, and DMA, DSA will be a catalyst for change in the United States, in Australia, as we have these different streams of policymaking. Are these different jurisdictions going to speak with each other about what works? Fourth challenge is going to be last challenge is experimentation and assessment. We're in a process of testing a number of different approaches, and that diversification is healthy. It's healthy in science, it's healthy in many areas of policymaking, and it's very healthy to be drawing our attention, maybe more than it has before, on the question of institutional design. Not just the question of what agencies should do, but how to do it. We're going to have lots of experiments, but that puts a premium on evaluation and assessment as we go along, a deliberate effort by any single actor and collection of actors to ask, how is it working, and to adapt their systems in light of what seems to work and to depart from things that don't. But it's a very exciting time for all of us who are interested in the question of how one actually does it, policy implementation to close the gap between the aspiration and its fulfillment.
Thank you very much, Bill, for those 4 challenges, and we will come back to some of them in the debate. And finally, Inge, what is your view on how to improve enforcement of the digital law in Europe?
Yeah, thank you, Alexandre. I would like to use my 5 minutes here to discuss a bit some insights that we gained from running these roundtables so far in the Digital Clearinghouse. And in the background notes and the discussions that we have had with regulators on topics like data sharing, how to regulate zero price markets, imposing special responsibilities on powerful platforms. Actually, there is a lot that shows us that the substance of the rules is mostly very flexible. But indeed, as already been said by the other speakers, it's often the effectiveness and the speed with which solutions have to be found that this is not yet effective enough yet. And I think one additional element is also that in these markets, it is often proved difficult to impose remedies that restore competitive conditions. Because certain behavior or certain practices can be stopped, but in some instances, much of the harm might already have happened. And this is, I think, one other element where we need to experiment more in enforcement, with really imposing remedies that could also create a more competitive market again. And I think in this sense, the Digital Market Act proposal is certainly a welcome and needed addition to the toolkit, because it could create more proactive intervention, because it really rebalances the position of the enforcers, in this case the Commission versus some of these platforms. On the other hand, you can also ask yourself the question if some of these provisions in the DMA go far enough. Most of the obligations seem to be based on existing competition cases, and I wonder if it would not be necessary to also take a more forward-looking perspective. So to give one example to make a bit more concrete what I mean, the DMA also focuses on giving additional protections to end users. And one example here is in Article 5 sub A, which is the prohibition to combine personal data across services unless the end user has consented to do so. And here I wonder if we can still see consent as a strong enough mechanism to ensure fair and contestable markets, because even and now I have an option to use a service, even if I don't agree with my personal data being combined across services. When I consent, also a lot of this data may be used to have effects on other individuals that might not have consented to this data combination. So if we care about making markets more contestable, and if we believe it is important to put limits cross use of personal data for reaching this objective, maybe we should not leave such important decisions in the hands of individuals. Then the second point I would like to make here is also that there is forms of enforcement beyond the Digital Markets Act in which we have to keep investing. And one area that has so far not come up yet is the area of merger review. And here I think this is a very clear example where there is still room and also need for synergies between existing regimes. And a recent example is, of course, the Google-Fitbit merger, where the European Commission imposed far-reaching remedies for approving the merger on competition conditions. But there is also room for the data protection assessment to complement such a competition review. And of course, it's up to competition authorities to approve a merger on the basis of their own methods of economic analysis, but also data protection authorities, I think, have a role there to do, for instance, a parallel investigation. And I think some of the tools we have in the GDPR, such as data protection impact assessments, could already allow for this. So here, I think there is still a lot of ground to be gained by applying existing regimes that have in parallel and let protection mechanisms complement each other, without these respective authorities substituting each other's rules. And I think it's important to realize that much of this is already feasible, I believe, on the basis of the regimes we have, but it is really about applying them and enforcing them in practice. And then one more example before I conclude. I think another important development that you see is that businesses have a lot of discretion on how to make key trade-offs with public interests. I think this is also an area that would need a clearer or more effective scrutiny in enforcement. And some examples we see now where national competition cases are being opened, where businesses are referring to data protection as a justification for not sharing data with competitors. And this mainly deals with the advertising sector. And indeed, there may sometimes be tensions between promoting competition on the one hand and data protection on the other hand. And this is something that needs to be tackled, but currently some businesses have a lot of discretion on how to go about this. And I think it's important that we also critically assess the legitimacy of such claims, because it might be that data protection is used at the same time by a firm for pursuing its own commercial interest. So to conclude here, I think there's a mix of things that are important, and there are existing instruments, future instruments that will become important, but there's also quite some boundaries to be pushed still on the basis of the rules and the mechanisms that we already have.
Thank you very much, Ing, for those first comments, and we will come back on Google Fitbit, I guess, in a minute. But first, I want to ask you to the two main enforcer or European enforcer that we have here with us. How do you think it's best to intervene in terms of sanctions? So, Marie-Laure, I was interested. You say, okay, fine is maybe not enough. We need maybe to order them to change behavior, if I understand well what you said in some of your comments. So I would like to ask you whether indeed you think that you have sufficient power as data protection authority to change the behavior of a company. So it's not enough to impose a fine. I fully agree with you, in particular when you have those big giants which are extremely rich. But do you think changing their behavior, you have enough power to do that, or not yet? And how do you plan to use those power in the future?
Well, thank you, Alexander, for your question. Regulatory action can change behavior, but so does consumer demand and concerns also. But I think, in fact, fines are important, but not only. We have to put also, you say in French, des injonctions, so that if actors do not comply, well, they are forced to do it, or orders to comply. I think what is important also with the enforcement action is that the public will be more and more conscious of its right. And we saw, for example, with the recent example of WhatsApp and the change of their privacy policy, that many people did not agree, and that's very important also that the public be aware of their rights, be very concentrated on privacy, and this is also a question of trust. And I think it's also very important for the regulatory action. It's a combination of consumer demand and the legislative framework that, of course, we enforce. I'm not sure I have responded to your question, but I tried.
Yeah, absolutely. Thank you very much. So I want to encourage the audience to ask questions. So we have already one, and I will come back to that in a minute. Andreas, I wanted to ask you, because you seem to say, if I understand you well, a commitment are sometimes, or maybe often, more effective than prohibition, and you give the example of Amazon versus your Facebook case. But no, then why in Facebook didn't you use commitment? Was it because the company didn't want? Was it because you thought that you wanted to create a precedent? Because I agree with you that commitment may be more effective, but why then not use it more?
I'm very sorry, I didn't get the end of your question because...
So the question is, if commitment is more effective, why don't use it more? Why, for instance, in the Facebook case, you didn't try to solve it through commitment instead of with this administrative decision?
Yeah, it takes two for a commitment. That's very easy. Huh? No, I mean, in every case, you have to look for the proper enforcement means, of course. First of all, I do not believe in fines. And of these companies, fines are a price. So fines must be extremely high in order to lead to a change of behavior. So I really don't think this is the way forward. We have two means as competition agencies to act in this field. One is, and that was important in the Facebook case, you can try to search for means to break up the dominance of these companies. And that is the rationale in the Facebook case, in fact. By asking Facebook to keep, they collect from various sources on Facebook, on affiliate companies, on third-party platforms and so on, to keep this data separate if the user wants them to. That is a means to restrict the dominance of this company and to give others a chance in this field, because we know very well that the dominance of these companies very often is data-driven. They possess the data that helps them to improve their services. They generate more network effects. So from this perspective, this is an important feature. Changing the behavior comes second for me. That is important too, because that is our task in the area of dominance cases. But if you can do something quasi-structural, I always talk in the Facebook case of an internal divestment of Facebook, I think that in the long run is even more effective than looking at behavior, because looking at behavior is always very nitty-gritty. Think of the problem of self-preference. I mean, what is self-preference? There you could go into the design of a certain website and could get lost in nitty-gritty proposals. So I think we have to do all of this. I mean, if you come to a settlement, it's good. That's the faster procedure for the time being, certainly. But again, for a settlement, it takes two. And if you don't have the feeling, if you do not have the impression that what the company is going for in a settlement is sufficient, well, then you have to go beyond that. And then you have to take a decision and go to court in order to strike for your views. It's just as simple. It's just as simple as that. And again, the new law brings a lot of advantages for us. I should mention that the federal in the future is the sole and first instance for decisions based on the new provision in the law that can cut procedures up to 1.5 years. And I think that is a huge step forward, that we do not have to go through 2 instances. Another feature is the shift of the burden of proof that we see to some extent. Companies have to prove that their behavior is justified. It is not us. They have to prove it. That's another important feature. So you see, you can do a lot by maybe not so huge changes in order to speed up the proceedings and in order to facilitate enforcement. And again, this is what we need. We need enforcement. We need real action, real impact on the markets, on the companies. That's what's needed. We have brilliant cases, but we need more impact.
Andrea, can I ask you another question, which came from the audience, from Peter van der Waal, who said maybe in the past we underestimate the market power of those companies. Now, I'm not sure that it was your case because you are one of the authority which intervened the first. But in the question there is the famous Facebook WhatsApp merger. No, it's of course very easy to criticize the Commission with a lot of benefit of insight, but but with those benefit of hindsight, 3 or 4 years down the road, do you think it should have been prohibited or no? So I don't ask your judgment of what the Commission did at the time, but we know no, and you know very well because you went with those companies against those companies. Do you think it should have been prohibited or no?
I mean, you know, years after, you always know better. I mean, there's a German proverb that says prognosis is such a difficult thing because it's about the future. I mean, this is true here as well. I mean, if we look at how markets have developed over time, I'm pretty sure that every agency around the world finds mergers of which it says, well, that would have rather have been prohibited. I mean, we also took a very close look at the Google Fitbit case that the Commission had been dealing with but from another perspective, because that merger was cleared on the basis of very long-lasting behavioral remedies, up to 10 years. That is a pretty long time, and one should be very aware of what one takes upon his or her shoulders here as a competition agency. So, I mean, sometimes it's not so easy to give a proper prognosis of strategies of companies, especially in this very innovative field in the digital economy. This is why I think it is fair that we all think about our merger regimes, and Inge has related to that, and I agree with her. Adopted this transaction value threshold over here in Germany in order to catch such transactions maybe easier. I think we must look for ways to look at it. But just my final word on that. I mean, these companies, sometimes they buy 10 other companies, not knowing which one will be successful and which one will not be successful. And 1 of 10 is enough for them. I mean, that's a fair deal from their perspective. So it is extremely difficult for a competition agency to say, out of 10 mergers, this is the one this is the one I should prohibit. I mean, then maybe you should even know more than the companies that are part of the deal. Extremely difficult. So I agree, merger control is extremely important in this field, but we haven't found the clue yet to deal with that in a way that it is really effective. That's really complex.
Okay, thank you. Bill, if I can come to you and on the same issue, the Facebook, WhatsApp. Okay, so first, do you think also there was an underestimation of their market power at the time? And do you think this action now that there is in the US to, in a way, come back on the decision of the US decision, do you think it has any chance to lead to something or no? And if yes, when? Because you say speed is of the essence here, so what do you expect from that specific action against Facebook?
It's a difficult case, but I think the Federal Trade Commission and the member states that are pursuing that case have a genuine prospect of not only prevailing on their theory, which focuses critically on mergers as the mechanism for acquiring and sustaining dominance, but they also have a very genuine prospect of achieving structural relief. Namely, in the FTC's complaint, a request that there be created one or more alternatives to the Facebook platform. I think that's a deadly serious request, and it is entirely feasible. You put your finger again on the question of timing. That result might come about 2, 3, 4 years from now. Unless there were an agreement by the parties to achieve a settlement. And sometimes, even in contention, that comes about. So short answer is, it's a genuine prospect of success. There's some doctrine that is very useful for the plaintiffs, the government plaintiffs. And I think Facebook has to take very seriously the possibility that they will be restructured. What about Facebook, WhatsApp? What about Facebook and Instagram? A very useful exercise would be to ask in both instances to reconstruct what did the public agencies look at? That is, what information did they have available? What assumptions did they make? What analytical techniques did they use? And in doing that kind of reconstruction, to ask, how do you do it better in the future? I think there were blind spots in the review of those transactions. And again, transactions examined by agencies that had a lot of experience, not just in the United States, but outside the United States as well. So I think a valuable step is to go back and ask, what did we do? Why did we do it? I do think there are a number of developments based upon an effort to go back and examine past experience to give us some insights about how to do a better job. I see a lot of useful, practical academic literature these days that talks about how to examine the acquisition by dominant enterprises of new competitors, creating presumptions that would force the acquirer to demonstrate the benefits associated with the acquisition. So I think, yes, were there blind spots in the earlier process? Unmistakably. But I think it's a useful exercise for us to go back and look. And it requires a degree of honesty by all of these decision makers. Who wants to have someone go back and take a look at what you did and point out respects in which you could have been better? It takes a lot of courage to do that. And the point isn't simply to criticize an oversight. There's no shame necessarily in making a mistake. The shame comes in making the same mistake again and again. So to go back and ask, should we have looked at other things? Are there factors we missed? And going ahead, how can we incorporate what we've learned into future work, but also to incorporate what many observers are developing now as a way to do a better job on this? And to just Google Fitbit, as you know, there's a large chorus of observers who said the only correct solution there was prohibition. So if we're going to take undertakings, even long-lived ones, it's crucial for the Commission to identify and document what its assumptions are about the effectiveness of these measures, to lay out the assumptions it has made that underpin the acceptance of these solutions, and then on an ongoing basis to look back and ask, in the light of experience, were those assumptions correct? And that puts a premium on the continuing assessment of what you've done. I know that that's a difficult thing to do. When I was a public official, I didn't enjoy having to go back and have someone else grade my work, but that's how you improve over time. That's the path to superior performance.
Thank you. And possibly one way also to do this review is by having this merger review and improve the merger review is possibly by having more cooperation between the competition authority and other authority, as Ing was suggesting. Now, I want to come back to you, Marie-Laure. Do you think, because you mentioned that you have increased your cooperation with the French competition authority on some case, do you think more specifically on merger control, like the Facebook, WhatsApp at the time, like the Google Fitbit now, the data protection authority should play a bigger role into the analysis, or no? And I don't want necessarily to focus specifically on Google Fitbit because we know that it was a controversial case, but do you think you should, I mean, the data protection authority at the national level and at the European level should play a bigger role in merger analysis, or you think no, I mean, it's different métier and each should do its own stuff? And if yes, how do you see the cooperation?
Well, we can have a role in assessing the data protection impact of mergers, including on data processing, but not substituting the role of competition authorities. But we have many links between the French Data Protection Authority, the CNIL, and the French Competition Authority. I will take an example, for example, because another mean to restrict this dominance of platforms, for example, is the right to data portability. During a previous discussion in Brussels in 2019, I remember Andreas had mentioned portability as one way to address the current competition challenges in our digital economy. And because it can give individuals the possibility of being independent of the platform or the service provider. And at the CNIL, we recently held a high-level event on the right of portability, addressing the challenges in terms of cross-regulation, the leverages for innovation and development, as well as concrete solutions to facilitate the flow of data between services while respecting, of course, the rights of individuals. And the French Data Protection Authority that I had invited was also participating by the voice of her president, Isabel de Silva. And this is an example, for example, of cooperation. And this right is important to develop innovation and new services, for example.
Oops. Okay. Thank you very much. I have a question of Matthew Newman, and that's an occasion for me to come back to the theme of harmonization, and I will remain with you, Marie-Laure, if you agree, because the question was addressed to you, but then I want to go to the others. And the question is, do you think that the Digital Services Act, which gives a lot of power to the European Commission for the biggest platform, for the what they call the very large online platform, is a good approach? Because clearly it's not the same as the country of origin principle that we have in the GDPR and that we had in the e-commerce directive. So do you think giving more power to the European Commission is a good approach, or do you think it would be better to rely more on the national authority, possibly better coordinated?
Well, the CNIL preliminary view on the DSA and DMA is that there is a need for more convergence and consistency between the various legal frameworks applying to the digital economy. So the Risk Commission's legislative proposal leave a certain margin of maneuver to designate one or more competent authorities responsible for the application of enforcement. even before the presentation of the DSA and DMA, there had been talks about a new EU digital authority that would need more powers and competences, concentrated body. I'm not sure this is the right approach nor the right solution. In the physical world, the regulation of economic actors is not conferred to one single body. We need to be consistent here as well. When it comes to protection of personal data while facilitating convergence and cooperation, it is important to maintain a delineation between the regulatory frameworks and the competences of the respective regulators due to the underlying principles of data protection and competition law are clearly distinct. Internal market and competition law aim at regulating market conditions, and Andrea and William could, of course, talk of this better than I could. But data protection law relies on the protection of a fundamental right. There is one important thing to keep in mind regarding the oversight of personal processing in the EU. The competence of independent data protection authorities is, I would say, constitutional, since it is enshrined in the EU primary law. Indeed, our Charter of Fundamental Rights specifies that compliance with the rules on the protection of personal data shall be subject to control by an independent authority. This has an impact on the framework and responsibilities that can be envisioned at EU level. But it is certainly useful to foster convergence and consistency between the various legal frameworks applying to the digital economy, to have a coherent model of data governance fit for the current digital economy, able to meet consumers' expectations in terms of trust and privacy, and fostering innovation and competitiveness for companies. That's, in my view, the spirit that should drive the discussion on the oversight and application of the DSA or DMA. I note in particular that specific provisions of the proposed regulation directly calls for greater convergence or cooperation. The DMA, for example, sets up obligations for gatekeepers that are directly linked to the processing of personal data, and specifies that I try to remember that the data protection and privacy interests of end users are relevant to any assessment of potential negative effects of the observed practice of gatekeeper to collect and accumulate large amount of data from end users. And the DSA also explicitly mentions that the effects for the exercise of the fundamental rights to respect for private and family life is an element to be taken into account by very large platform as part of their risk assessment obligation. So not to be long, coherence of the new proposals with the EU acquis in the field of data protection is essential to provide for an efficient and readable framework for oversight and enforcement.
Thank you very much. Andreas, the same question for you, but in another context. You know, there is this harmonization clause in the DMA, which is to say that the member states could not take additional law regarding what the DMA is pursuing. So that do not, of course, impede the German law you mentioned, because the German law is about competition law, while the DMA is more about regulation. But still, how do you see I think legally it's okay, but I mean, in practice, there is some tension there between the DMA, which want to harmonize, and then member states like yours, which have taken a law. So how do you see this tension and how it can be dealt with?
Yeah, Alexander, I think we have a double goal here. I think the first goal, of course, is to have consistency and coherence in our decisions. We are 27 member states now within the European Union, and it should not happen that some companies are subject to 27 different decisions. So that's of course one point. Another point for me is also we should go for this competition of innovation and of ideas also that we have in the European Union. So if you look at the DMA, I mean, it foresees, as far as we know today, a very a key role for the European Union. I mean, we're still discussing the DMA and what it will look like. But as far as we know, the preliminary view that we have is that the Commission is going to designate the gatekeepers, and it is going to ensure that the gatekeepers do comply with the DMA. There doesn't seem to be very much room for national competition authorities. On the other hand, we also must be in line with the stance of our federal parliament here in Germany, which, when it passed the amendment of the German Competition Act, said that it also wants to see a strong role of national competition authorities in the future over here in Europe. So I think this is a question of institutional design in the future and how we proceed over here in Europe. I think we have good and bad examples how institutional design can work. A maybe not so good example for me is the mechanism of the GDPR, because here everything relies heavily on one national competition, on one national agency that excludes, to some extent, also European institutions. I think at the competition side, we have a very well-working system because national competition authorities also apply European competition law. But the European Commission is primus inter pares, that takes care that we have a consistent and coherent application of the law. But we also have, of course, a competition among competition agencies to a certain extent when it comes to new ideas, when it comes to innovative ideas. And I think this is very important. Plus, I mean, all resources are limited, even those of the European Commission. They cannot do all the cases at the same time. So why not share this burden with those competition agencies in Europe who can do it? And I think that would be a great idea. But again, we need consistency, we need coherence, and this implies that we also need a cooperation and coordination mechanism in Europe that maybe is even stronger than the one that we have today in the competition field. Because we have to take care that we do not have double cases, that we don't spend double resources on cases. And maybe even more important from my perspective, we can never ever go for contradicting remedies in certain cases. Everything has to fit together. And this is why I believe a new sort of cooperation within the European Union in order to make sure that we reach both goals, that we keep up the competence of national competition authorities, also with regard to a certain burden sharing, allocation of resources, but at the same time to guarantee consistency. And by the way, maybe we should take care for that even in a broader scale, which means worldwide. I mean, I think it would be very well accepted if we had some mechanisms that make sure that we go in the same directions in all kinds of continents. You see that already today to a certain extent. When you look at, for example, how certain agencies and regimes are dealing with Google on the one side and the publishers on the other side. You see parallel cases in France, in Australia, in other places of the world. And I would be very happy to contribute to that as the head of the steering group of the International Competition Network. That cannot guarantee that we come to always good results, but we can work towards that and we can invest resources into reaching that goal.
Thank you very much. And by doing so, you address one of the questions by Arthur Dosias, who said maybe 80 people, that is what is foreseen at the Commission to implement the Digital Market Act, won't be enough. And so it's true that all the resources that you have in the national authorities could be very helpful there. Bill, I want to come to you on two things. So first on what has just been said by Andreas on this cooperation also beyond Europe. Do you see the American administration being open to this new administration being open to this kind of cooperation to enforce better the new rule on the big platform? That's one question. And then another question is, from your experience as at the chair of the FTC in the US, do you think it would make sense to have an equivalent in Europe? Because that's a bit what the DMA is heading for, the European Commission becoming a kind of, not federal, because we should not say federal in Europe, but a kind of a quasi-federal trade commission. So on this dialogue with the US administration and on this model of the FTC for Europe, what is your thought?
No, they're great questions. I do think that now, I guess it's 8 days ago, with the regime change in the US, there's now going to be a conscious effort to restore international relationships that in many ways have been damaged severely in the previous 4 years. So I think there is an openness now to re-engaging through a whole host of institutions dealing with the domains we've been talking about and others. So that's a very positive first step towards the expansion of national cooperation efforts. We read yesterday that the executive vice president for the European Commission has announced her interest in developing a closer dialogue with the United States on matters related to DMA, DSA. I think that will happen. Ideally, that conversation would have intensified over a year ago, but better late than never. And I think the Biden administration will seize that opportunity. And we'll see a intensified effort to both promote understanding, interoperability, and perhaps consistency across systems. I don't want to minimize the fact that there will remain perhaps conflicting views about what to do, but it is very significant in the United States to have observed the fall of the big tech platforms from being national idols, national treasures 10 years ago, to being pariahs today. Their political standing has fallen dramatically, and there is a growing mood for intensified regulatory oversight that comes from the left and the right. So a short answer to your question on cooperation is that this is exactly the moment for an expanded discussion between the United States and the European Union, between the United States and the United Kingdom, between the United States and a host of other national institutions and multinational institutions. That's going to happen. That ought to be very fruitful. The FTC experience is interesting on this point. The Federal Trade Commission incorporates not simply competition and consumer law, it's the principal US data protection authority as well. And there are benefits to having a centralized focus on the policy integration that we've been talking about before. Now, member states in the United States have extraordinary ability to go on their own policy direction without being ousted by national decision making. And you can make a pretty good case that one of the most powerful data protection authorities in the world today is the state of California. US data protection standards are basically being set through GDPR in the state of California. We'll probably have a national privacy law as well. But there are clearly benefits in the FTC experience from having these disciplines in one house, plus an expansive research and analysis capability that gives you the better ability to diagnose problems, to identify potential cures, and to suggest how the implementation of remedies should take place. My guess is in Europe, that's simply a bridge too far. So realistically, you'll have some centralization, and the DMA anticipates that, I think wisely, for the reason that Andreas mentioned before and looking at the GDPR experience. But the real challenge is not going to be to integrate by ownership, integrate by merging these functions into one place, but instead to integrate by agreement across different institutional boundaries to make things work better. Although, if Europeans want to study examples of whether or not that integration would be desirable, you can look at the Dutch experience with the ACM and consider whether or not a combination of more regulatory functions, consumer and competition functions is something worth doing. There's a lot of opportunity here to look at experiences at home, and though they're not part of the European Union today, to look at the experience of the CMA and how the digital markets unit evolves. Here again, I think the ideal mix is one that Andreas referred to. It's a degree of decentralization that allows experiments to take place to identify promising new approaches, but you have to have a mechanism, to go back to Marie Lauer's point before, to achieve coherence. And that is a mechanism that brings together the lessons of the decentralization and establishes standards and approaches that are applying to the entire community to have that mechanism approach. There's tension there, but that's the framework you want, and it does not happen by accident. That requires conscious, dedicated efforts to build the synapses that make those relationships effective.
Thank you. Thank you. Now, Ing, what do you think about this issue of harmonization and to improve enforcement? Do you agree with the direction that the Commission is taking, more centralization? Do you agree also with the previous speaker that we still need to experiment at the member state level? What is your view on the way forward?
Yeah, it's a complex issue because indeed we are dealing here often with very powerful players. So to a certain extent, it makes sense to harmonize this at the EU level and make sure there is one authority in place that can monitor the behavior of these companies that are active in cross-border practices. But on the other hand, I also see the need for burden sharing, for sharing of resources. And I think in particular when it comes to regulating data markets, there's also a need to add additional expertise to the teams and the case teams that already exist. And at the national level, some competition authorities may already have more experience with this than the European Commission. So I definitely also see the room for including more national authorities in this sense. And I think one other element I think that is interesting is how also the collaboration between the DMA as a more economic instrument which aims to ensure contestable markets, with also the data protection elements that are included in there. And in the discussion earlier already, the right to data portability came up. And indeed, the DMA also wants to strengthen this right to data portability when it comes to gatekeeping platforms. So here a question is how this enforcement will work in practice. Will the European Commission now start to enforce a right that was included in the GDPR, which indeed has a fundamental rights origin? And how will data protection expertise be implemented in this sense? And I think data portability is an interesting concept in this regard, because it's really a hybrid notion which comes from the data protection thinking, but of course also really can stimulate competition and complementary innovation in data markets. So I think when enforcing the DMA and when taking on board additional cases, there will always be a need to include expertise from authorities beyond the European Commission. So I think it is indeed important to find a way to keep this centralized model, because that will probably be the most effective one. But there should also be a possibility for national competition authorities or national data protection authorities to be involved and to make sure that the analysis is coherent. Because what I see is that a lot of the practices of these players really bring the different regimes closer together. And so that means that you can no longer interpret or apply a certain regime by ignoring interests that are protected by closely related regimes. So no matter what, there will be a need for stronger collaboration and stronger alignment.
Thank you very much. We are about to finish, so I want just to give the word to the two enforcers that we have with us today. And you know, we are in January, so it's the time of the good resolution for the year, you know, and so I wanted to ask you, both of you, what will you do to improve the enforcement this year? What is your main resolution of the 2021 to improve the enforcement this year? So maybe we can start with you, Andrea, and then I finish with you, Marie-Laure, but so please be very quick, because otherwise, if you have a too long wish list, I will come back next year and some won't be met. Please, Andrea, and then Marie-Laure.
Yeah, just very briefly. I think all of us on this panel today, we share values. We have the same values. We want to protect our democratic and freedom-driven political framework. We want to give choice to the consumers. We want to protect consumers. We have lots of tools to do all this in the in the analog world. And I do believe that we in Germany and in Europe as well, we will have much better tools to protect exactly these values also in the digital world, in the digital economy. And I think that is our task for us mainly now, because we already have the tool, the German law, the amendment of the law is in place. We will try to make use of it. We will apply it this year. We will initiate proceedings. We will investigate. I hope we will bring cases to an end. And maybe we should meet again in 1 year. And you can ask me, Andreas, how was 2021? And I will report. And I hope I have good news for you.
Thank you very much, Marie-Laure.
Well, thank you, Alexander. I wish that we make more enforcement tools available. The CNIL has many tools available, but more of them. Create also more synergies and cooperation with other regulators at national, European, and international level. And there's no choice but to succeed to achieve the goals mentioned by Andreas and preserve our shared values.
Thank you very much on that optimistic note, and I hope we could have another discussion indeed, as Andreas was proposing, on the case, on your activity of this year. I would agree to thank you for the time you take, because we know that we are all very, very busy. I would like to thank the audience, and I am sorry I could not address all questions. In particular, there was one question on private enforcement that I thought was very interesting, but unfortunately we don't have time. Maybe also for the next year. And I would like to also thank the CPDP organizational and technical team. So all the information on the Digital Clearinghouse are available on the website, digitalclearinghouse.org. And so if you want to share also some ideas, don't hesitate to use that platform. Thank you very much to all, and see you in another webinar, I guess. Thank you very much.
Thank you, Alexandre.
Thank you.
Have a good time.